Professor Porter, we're talking about criminal law and entering into inchoate crimes. And essentially, this is the overview of all inchoate crimes. When we're talking about inchoate crimes, we're really talking about a few different types of crimes that apply more widely to, sort of any underlying crime. So we're talking about attempts, attempting a crime, doing something in the direction of committing a crime. So it's we're really talking about going in the direction of something, taking what's called a substantial step in the direction of committing a crime can also be a crime. There's kind of two varieties that we'll talk about it as well. Next one has to do with solicitation, and that's asking someone to commit a crime can be a crime. So you can see, for attempts, we can have attempted burglary, attempted murder, attempted larceny. For solicitation, we can have solicitation. We can ask someone to commit a murder, ask someone to commit a burglary, ask someone to commit a battery. So it's really applies widely. Sometimes it's included in the same statute. Sometimes it's an independent statute that applies to all other substantive crimes in a penal code. The next one, that's a big one, is conspiracy. So solicitation is the person that's doing the asking is asking someone to commit the crime. Conspiracy is more of a two-way, two or more person is an agreement to. So oftentimes we talk about a doctrine called merger, where it might be solicitation, where I, as the defendant, am asking someone to commit a crime. I'm asking someone to commit a burglary. But once they agree and we start to plan and we start to take steps, we really have a conspiracy then, because you have two people that have engaged in a crime, but both sides of the agreement and everything that flows from the agreement is going to be essentially conspiracy violations. The last one that also fits under inchoate, so we talk about attempt, we talk about the asking and solicitation, we talk about the agreement of conspiracy, sort of accomplice liability. That's what we're really talking about. There's a principal, there's a main person that's committing the crime, the orchestrator, the main person that's committing the murder or the burglary or the larceny. And then they have others that are helping them out, whether they're encouraging them beforehand or helping them in some way beforehand, helping them during. That's your classic getaway driver or lookout. Those are accomplices. They're accomplices that are relative to the principal that's committing the act. And then you also have sort of folks that are after the fact, helping cover up or helping to hide folks and that type of thing. But we're really talking about then it's encouraging and insisting another to commit a crime as a crime. So you can see here, it's these brand of crimes that sort of can layer on top of any substantive crime. You can attempt to commit a burglary. You can ask someone to commit a burglary and therefore commit a solicitation offense. You can agree with someone to commit a burglary. That way you're both on the hook and you're both potentially criminally liable for just the mere agreement to commit a burglary in the future. Or maybe I'm the principal, I'm the one that's going to conduct the burglary, but I've been encouraged by someone in the pregame, or I have someone assisting me during, or have someone assisting me after with some crucial roles in committing the offense. So these are the types of things that we're talking about that are branded as inchoate offenses. And a couple of things they have to remember about inchoate offenses: all specific intent. They are all specific intent offenses, which becomes relevant again because we're talking about what defenses may apply as well. Well, here's what I like to think about, and here's a way of approaching thinking about inchoate offenses, especially as it relates to the underlying crime. There's essentially a lesser version of the actus, right? I might need to go all the way to doing something to commit a burglary. I got to break and I got to enter into a house. For the larceny, I have to take and I have to carry away. That's what's required. Well, the different versions of the inchoate offenses, right? They require something lesser. I might not have to go all the way to the breaking and entering. I might not have to go all the way to the taking and carrying away. That's required to essentially complete the offense. So there's something less required. And if you think about, the attempt, we're going to talk about it. I've already mentioned the term. That's the way what the model penal code uses, and a lot of statutes take from it is, this substantial stepped idea that, I didn't commit the robbery. Instead, I took a lot of different steps. I cased the area. I looked for potential victims. I got in a car that wouldn't be identified with me. I I look to see what the law enforcement reaction would be and the traffic would be, and I got some different instruments for the robbery to make sure that I could take it. I've taken all these different steps, and in the aggregate, could they equate to a substantial step? So notice it's lesser than actually going forward and completing the whole crime, because maybe I don't show up on game day, maybe I don't go forward with the actual robbery, but have I done enough in the aggregate to commit the substantial step? So it is in a lot of ways a lesser actus rea. Same thing with the solicitation. I mean, really, we're talking about the act is just asking someone to do it. It's lesser than if you were the actual principal. Same thing with conspiracy. You're agreeing, and it's just the mere agreement. I get together at my office, I meet with someone, I say, hey, we're going to take these steps to burglarize this competitor's office, and here's what we're going to do, and here's the way it's going to work, and here's going to be our roles, and here are the opportunities that we have to do that. Well, just that mere agreement is going to be enough. I don't actually have to, again, get to game day and carry out the plan. So in a way, solicitation and conspiracy, just the mere asking, just the mere agreeing, is the actus, and it's something less. And the same thing with accomplice liability, right? I'm merely encouraging someone who's committing this as a principal. I'm merely assisting someone who, either before, during, and after, who's going forward with this crime. So if you have this in your mind that these inchoate offenses allow you to sort of have your act be limited in some way, be lesser in some way, the trade-off is, and I'll submit to you, the trade-off is that there's a heightened mens rea that's involved. You do less, you act less, so therefore we require more with what's going on in the brain. And the more really it ends up looking like this. With an intent, I have to actually intend to do the acts that I'm doing that equate to the substantial step. I have to intend to case the place when I'm going there. I have to, knowingly look for my victims and get prepared to go forward. But I also have to have sort of this dual intent. I have to attempt to, knowingly do the things that I equate to my substantial step, but I also have to specifically intend the underlying crime. So if I'm attempting a burglary, as I'm engaged in these steps, I have to specifically intend to commit burglary, right? It's a heightened requirement. Same thing with solicitation. As I ask someone to commit murder on my behalf, I have to, with what's going on in my brain as the person that's guilty or the person that's alleged to have committed solicitation, I have to have the specific intent to commit murder as I'm making that request. Same thing with conspiracy. If I'm conspiring to rob that competitor's office, I have to knowingly engage in my act, which is the agreeing, but then I also have to specifically intend the robbery of the competitor's business that goes on at the same time. So it's two parts of intent, and it always has a specific intent to commit the underlying crime. So one of the ways that you can think about it conceptually that applies to all inchoate offenses is a little lesser on the act side, but a little more on the mens rea side. That's the trade-off for that applies generally for all inchoate offenses.